afternoon, ladies and gentlemen. My name is Peter Keene. I'm a professor of law here at Golden Gate University and former dean. Dean Rachel Van Cleve was going to make the original remarks relating to the Jesse Carter set of lectures that we've been having, and then I was to, which I still will, introduce John Burroughs, but Dean Van Cleve was taken ill, so I'm going to talk for a few moments about the Jesse Carter lecture series and the background of it. Jesse Carter was a graduate of Golden Gate University School of Law, one of our early graduates, the class of 1913, so that was early. The school started in 1901. Jesse Carter is probably our most, not probably, I think he's our most illustrious graduate. He went on to the California Supreme Court, and on the California Supreme Court, Jesse Carter became known as the lone dissenter. I mean, there have been on courts people who have gotten fame from dissent, Oliver Wendell Holmes and the free speech cases, but Jesse Carter was a character unto himself when it came to dissenting. Jesse Carter dissented in an enormous number of cases. And he didn't dissent just because he was a contentious character. His dissents all had great principle and great heart behind them. I was just talking to John about one of the dissents that I had read that Carter had done back in 1940. And you read the dissent, and what you're reading is the Miranda decision of 1965 in terms of the whole aspect of protecting someone's right against self-incrimination. Jesse Carter was reflective. He came from a very simple background, and he went to school here at night when this was a night law school, which it was for a great part of its history, over at the YMCA building. Jesse Carter is reflective of much of what is the best of Golden Gate University, and that is Golden Gate University Law School turns out lawyers who are centered into public interest. They're people-oriented, they're not money-oriented. Nothing wrong with money. They make a lot of money too. We're always glad of that. I was particularly glad of that when I was dean and I was fundraising. But in terms of the great ethos of Golden Gate University Law School is public interest, service, and the use of law for the benefit of people, and the benefit of humanity, and the benefit of individual rights and individual dignity. And in the spirit of that, we have as our speaker tonight someone who is also emblematic of those particular principles. My old friend John Burroughs. I've known John Burroughs probably for almost 40 years. I knew him when we were both originally back in the trenches as young lawyers in the criminal justice system back in the 70s. John Burroughs is known and recognized legitimately as one of the great trial lawyers in America. And that, you can use all sorts of high-blown rhetoric, but that is not something overblown. John Burroughs is someone who has had an enormous contribution to jurisprudence in the United States, in California, in regard to the practice that he has done, mainly having to do with cases involving police brutality and police overreaching. John originally was hired by the mayor of Oakland back in the mid-1970s to investigate the shooting of a young African-American male. And out of that came a path that took him into all sorts of areas having to do with incidents like Rodney King, other types of, you name it, in terms of police overreaching, not just in Oakland and the Bay Area, but all around the state and in other places. John Burroughs has been there as a principal individual to vindicate human rights where authority has gone out of control. And he's done that by working creatively and and beautifully to put together a case. He is a master of facts. That's what a great trial lawyer is. And he constructs facts in a way that are completely, you can't argue with them. And brings them alive to juries, and the juries react with big judgments in the millions of dollars, which you can look at. If you're going to look at it just in terms of money alone, it's impressive. But what it also is a vindication of someone who has had some terrible tragedy, like had a family who's had their son or daughter taken from them, or someone who's been harmed and hurt. And there's some attempt to have some retribution in regard to money judgments, huge money judgments that have been won. But the money judgments are impressive not because of the figures, but because they illustrate the fact that law has been vindicated by the kind of judgments that John has. You're about to hear a lecture by one of the most superb lawyers in America today. It's my great pleasure and privilege to introduce John Burroughs.
Peter, Dean. How you doing? It is true that I have been involved, but let me just say on the background ways, I am a graduate of Golden Gate College, University, and I'd like to say back in the day. During that period of time, I was an erstwhile accounting major, and I ultimately got a degree in accounting and went on to work in a major CPA firm. Because back in those days, accounting was the mainstay of the undergraduate school, and I don't know if that's still true, but certainly I did that, and it turned out to be a very good training ground for me because it allowed me to analyze balance sheets, accountings against basic principles. So I have a great deal of fondness for the school and what it did for me. The second portion I would say that I think what Peter mentioned, and that is really great trial lawyers have come from here. I certainly have worked with a number of trial lawyers who have come from Golden Gate Law School here, and they've been fabulous. And I think it's also true is because it's the nature of the training that you get that is related to people and people's interests. So in that sense, all of you should be proud of the choices that you made and the potential careers that you may have as public interest lawyers. And that runs the entire gamut. It's not just public defenders or DAs or city attorneys, but wherever you are, you will be in a position based upon your training to make a real difference in the profession. Now, a little brief mention of the kind of work that I do. My practice is essentially a civil rights practice. And when you look at it, it's the federal laws. It's one that's I refer to it as my tools. These are my tools that I work with every day. It's like a carpenter has his hammer and nails. Well, these are my tools. And it's Section 42 USC 1983 and the Bill of Rights. And in the state side, it's 52.1 and 51.7. These are the frameworks that I apply the facts to these bodies of laws. And they're very important. And I was giving a speech earlier today, and I made reference that when I went to law school, these particular statutes were not being used. These are really modern day, relatively modern day uses of these statutes, even though 1983 has been on the books since Reconstruction. It was not effectively used in civil rights cases until the 1970s and early 1980s. And so the most significant statutes are the Fourth Amendment, 5th, 8th, and the 14th, all of which allows me, no matter who the opposition is, no matter how many lawyers on the other side, no matter how strong they feel about it, that if I have facts that fall within these particular statutes and Bill of Rights, I'm formidable. I can do the work. And so I want you to keep all that in mind, is that part of what you have to have here is your sense of where you want to go and make sure you understand the particular laws that applies to your fact pattern. I have done a lot of employment work, been involved in class actions. It was a while ago now, but in '99, I did write this book called Blue versus Black, let's say the conflict between police and minorities. And the reason why that was important at that point in time, I had just finished the Rodney King trial in '94, which was a huge trial at the time. So the first trial that gave a window into police misconduct for the greater population and for the world, because there was always this sense that justice could be, the police did not abuse their authority. Now I knew differently, having been involved in police cases long before Rodney King, that just wasn't the case. But there wasn't a lot of public discourse about it. So Rodney King really allowed for that. And that video really illustrated the type of brutality that can be heaped on people. As a backdrop, I would say this. I know Peter mentioned that in 1979 I got involved in a police shooting case in the city of Oakland, and it really sort of put me on the path of understanding and appreciating police misconduct. But I will tell you, when I was in law school at Berkeley, I did go to Chicago and work a summer or two with this law firm, Jerry & Block. And during that period of time, there was a major event that took place where the congressman at that time, Ralph Metcalf, had an experience where his best friend, who was a physician, was beaten up by the police. And politically, he and Mayor Daley at the time were on the same page, but they parted ways on this case. And so for the summer, I interviewed hundreds and hundreds of people who had been victimized and beaten up by the police, and it sort of left a mark on me that there's this serious misconduct that's taking place. And it sort of, in the back of my mind, set me on the course that I've been involved in. You may wonder what kind of career you start out with, but I did start out as an associate, and I went to the assistant state's attorney in Chicago, where I was a prosecutor, and I did many homicide cases. Then I came down to the county, where I was also a prosecutor before I went into criminal defense work in private practice, which was, I think was an opening into the police and seeing it from the perspective of both the prosecutor's office as well as that from criminal defense. But ultimately, and the part I want to talk more about here as we get into it, is that these are the kind of issues that affect the life that I've been involved in. Race is extraordinarily important in the practice that I'm involved in. I know that people like to think that because we have an African-American president, that we're in a post-racial society. That's just absolutely not true. It has nothing to do with the day in, day out work that we're dealing with. Many of the cases I'm involved in are very high profile. Like it or not, when the police are involved, and they kill people or beat people up, those are news cases. And so many of the cases I'm involved in are in the news. And so I had to develop a strategy on how to deal with the media in various cases, which is an art form, and most lawyers don't like to deal with it, but I have found that in order for my best interest of my client, it is important for me to be able to deal with the other issues. Now, underlying a lot of this is the question of racial profiling. It's an aspect of police misconduct. I am on the ground dealing with issues of racial profiling and certainly police misconduct. The vast majority of my practice, over I'd say 85–90% of the cases that I'm involved in, and deal with some form of police brutality. And that includes just basic shooting cases. I hate to say basic shooting because, they're not basic. Someone's been killed generally, and there's a lot of issues and a lot of emotions around that. But beating cases, false arrest, suicide, jails cases, you name it, I have been involved in looking at that. The other aspect of all of this that's extraordinarily important, and that is sort of this implicit and actual bias that I have found in the judicial system. It is important because decisions about who gets what sentence, who gets arrested, who gets charged, in fact can turn on race, and I'll talk a little bit more about that. Mass incarceration is one of the great scourges on our society right now, where we're incarcerating huge numbers of people, ostensibly based upon discriminatory enforcement of the drug laws, and they have a tremendous negative impact on society, certainly as it relates to the practice that I'm involved in. The other issues, Michelle Alexander's New Jim Crow is a book that I've said that everyone should read. It really goes to the legalization of a certain level of discrimination, and she refers to the Jim Crow, New Jim Crow, and I'll talk more about that. There's some good news that's happened more recently around the marijuana legalization, and the reason why that's important, because there's a disconnect in terms of racial bias in the enforcement of the marijuana laws. And for those who don't know, I've certainly been a legal pundit, I've been called worse, but that's one of the titles I have. It's quite amazing what people say about you when you do that kind of activities. I have done, and most importantly for me, beyond the case themselves, and this is lawyers as you get involved in wherever area you want to go, is how do you improve the system that you're involved in? It is one thing to deal with a case, but then how do you make the case bigger? How do you make the conditions of the case bigger than the four corners of the case? And that's when you have real impact in terms of the future aspects of the areas that you're working in. And certainly for me, it's always been important to look beyond the case itself and see if I can bring about some kind of change and some kind of reform. The most significant case in that regard has been the Oakland Riders case. That was a case where 4 officers back in the early 2000s was riding around Oakland, beating up people, arresting them for cases that they had crimes they had not committed, committing perjury, planting dope. It was now a scandalous form of conduct. I represented, Jim Shannon and I represented 119 people in that case. And we ultimately settled the case for a significant amount of money. But the most important part of that case, which I was able to use that case to change and rewrite a lot of the policies and procedures within that department. We're still involved in that case. We've had we've had an independent monitor involved in the case that has evaluated whether the police department has complied with the terms and conditions that we have set forth in the agreement. And we have a federal judge. Fortunately for us, we have the best federal judge. We have Delton Henderson, a federal judge who is not only in charge of our case, but he's in charge of monitoring the prison system and trying to deal with the overcrowding and also the providing of medical, good medical treatment within the prison system. So this case has gone on for a number of years. I have met with the police department every month for almost 10 years. And there's been peaks and valleys. 3 mayors have come in, 4 or 5 police chiefs, 4 or 5 different command staffs, but I'm still there. And my overall sense, as I tell them, and I did tell them at the very beginning, and this is what I know about policing, everybody in this room will not be here when this case is over, but I'm going to be here. And what has happened, we've had 2 or 3 different changes of everybody in the room, but Jim Shannon and I are still there, and we're there because it's the future of the department and the future policing that is important. And for me, it's extraordinarily important because the people who are the victims in Oakland are essentially African Americans. And so for me to let them know, the police department, that I'm not going to take this is not going to happen on my watch, has been very, very important. And so we are making some progress. It's been a very difficult challenge for us, but we're still there. The other issue that was important, other issues are important, but one of which is my favorite, is called public strip searches. And this is what happens. OPD was stopping African American males, and they would, if they thought they had drugs on them, they would cause them to pull down their pants. And I mean this literally, pull down their pants, search their private parts, either with their bare hands or with gloves, and essentially humiliate them. Well, to me, this was a modern-day mystical activity on their part. And I was furious about this, and I represented over 40 people who had been victimized by this. Not only did I get them a substantial amount of money, but one of the federal judges declared the practice that they were involved in as unconstitutional. And so now you cannot have public strip searches in the way in which it was done. And we haven't had any of these cases in the last several years after we were able to put this policy in effect. It was very personal to me, and I wanted to make sure that it was not going to happen anymore. And the other matters, you know, one of the more interesting employment matters that I've been involved in. And this is a case where we got a jury verdict, but in the state prison's correctional facility up in Pelican Bay, the inmates were engaging in a form of masturbation. Exhibitionist masturbation was the term that was used, and it was done for the express purpose of intimidating the women correctional officers. And the male officers and the supervisors would not take any action to correct this. They didn't try to protect the women, and so we sued them on that grounds, and we got a nice verdict, but more importantly, we were able to get a series of reforms that the department had to impose to put in place a mechanism that says when this happens, the supervisor is supposed to take certain action, and the people who engage in the conduct, certain things had to happen to them. It was a wonderful way to resolve that, and it got imposed in a number of, most of all, the reforms that we had were put in place in just about most of the Department of Correction facilities in Northern California. And it's one of those kind of things that you never know when you're going to have this kind of impact in cases. And we've certainly done that in a couple of class action cases I've been involved in where you had that. Early in my career, I was involved in a case that went to the Ninth Circuit in canines. The department had a practice where that they would send a canine out and they would find and bite. And many of these times they would bite, these dogs would bite when a person had literally tried to surrender. And so we were able to, after going to the Ninth Circuit, were able to cause the department to change their practice from fine and bite to fine to bark, fine and bark. And that became extraordinarily important because we haven't had part of these cases in the future. And to me, if you haven't seen a lot of dogs chewing up people, you don't know how painful and irresponsible it can be if you allow for that to happen. But we were able to cause that not to happen. So I've been very fortunate about that. But now I want to talk, before I get to the other case, Trayvon Martin and Austin Grant. Part of what those cases represent to me is this, particularly African American community and others, fair-minded people, really believe that cases where there's an undercurrent of race can in fact be resolved in the criminal justice system with race being part of it. And there's a lot of history to suggest that doesn't happen. Cases that most African Americans are very familiar with, Emmett Till, which is a 1955 case. I was a boy at the time, and I was frightened by this case. This was a boy who was assaulted and killed in Mississippi for whistling at a young white woman, and he was brutally assaulted and killed. The killers were found. They had a trial, and they were found not guilty. Now, this is a national case. It was a case where race was at the centerpiece of it. The boy was only attacked because he was a young African-American male. But yet, when it went to trial, he was found not guilty. And race was not part of the case. And so the public and African-American expectations was that because it was killed because he was race, then that should have been in the story. But it did not happen. And many years later, when the climates have changed, that a trial was held in federal court. And the difference is this: you can have a state case where a person is found not guilty, but if you think it's race, the federal government can come in and try that case again. And it's not double jeopardy. We saw that in the Rodney King trial, where the officers were found not guilty in state court for assault and battery, but then the feds took him to federal court and charged them with violating the federal civil criminal statutes, which is another approach to it. But Medgar Evers was a case in 1963 that where he was an NAACP field worker, and he was assassinated at his house. At the time, he was working hard to try to register African Americans to vote in Mississippi, and he was gunned down by the Klan. The problem with the case, of course, is the people who did it were aware, the nation was watching this case, and they were found not guilty. Race was a big issue, but it did not find its way into the judicial system at the time. I talked a little bit about Rodney King already. First time that case, now, Rodney King, for those you who are maybe young enough not to really know or appreciate, was a huge media case at the time. It was as big a case as one could have. We have a lot of discussion about Trayvon and his case, but I'm going to tell you, the Rodney King case was as big, if not bigger, because there was this video of him getting beaten by these cops in a most horrific way. And the worst part of the case, I mean, this is a case that went viral all over the world, and so when the officers were tried, 4 officers were tried in Simi Valley, which was a city right next to Los Angeles, they were found not guilty. And it was one of these things that the African American community could not relate to. And in fact, they rioted. There was a huge outcry and mass destruction that took place. But again, race was not something that was brought up in the trial. It was not evidenced in the trial. But the community watching this really thought that race was an issue and that the criminal justice system would deliver justice. Sadly, that was not the case. And the other 2 cases are more modern cases, but they're really the same thing. Amadou Diallo was a young West New Guinea African-American male in New York at the time. He was stopped by the police. He was trying to get his ID out of his back pocket. He was shot numerous times by the NYPD. Sean Bell, the same thing. He was on his wedding night, his party that you have, a bachelor party, and before he was getting married the next day, and he was shot and killed by a number of officers who really never offered anything. Both these cases went to trial, and each of the officers were all found not guilty. And so there's this sense that race is an issue in the case, but it doesn't necessarily find its way into the jury verdicts. And when the police is involved, that's a whole other issue, because police are communities are unwilling to find police officers guilty of crimes that occur in the course of their business. Racial profiling is an area that I've done a lot of work in, and this is essentially what happens here, is that race is substituted for reasonable suspicion and probable cause, and it causes people to be stopped. It is pretty clear that this is it's a violation of the Constitution, but it happens in the African American communities. Here are some kind of contemporary terms that everyone in the African American community is aware of. I'm certainly aware that these are things that I have to counsel people about: walking while black, driving while black, being black in the wrong place at the wrong time, or just being black. That can cause you to be stopped by the police, and whenever you stop by the police, bad things can happen to you. Racial profiling stereotypes that we have to try to counsel young men about, and that is, that they have to watch out for the clothes, the neighborhood, the time of day, and etc. But these are 4 real issues that the African American men in the communities have to deal with on an ongoing basis. And I've had many cases where young men have been stopped 20, 30, 40 times, told to get out of the car is searched, nothing is found, and then they go on their way. And you might think that that's not a major intrusion, but if it happens to you, it really is. And so I'm always very upset about those types of cases, although sometimes I can't do much about it. But let me talk a little bit about Oscar Grant and Trayvon. I was involved in the Oscar Grant case from the very beginning. When this happened on January 1st, 2009, I probably got a call late that day, and I responded to the family immediately. And what happened in this case, if you don't know all the details, if you haven't seen the movie, I'm not in it, so just thought if you haven't seen it. Oscar Grant was a young man who had some issues in his life. They had gone out on New Year's Eve, went to San Francisco, down on Montgomery Street, just kind of hanging out for the thing to, when the bell dropped or whatever dropped in San Francisco. They then got back on the bar and was riding back. The plane was crushed. On that plane, on that train, there was a person that knew Oscar and knew him from either county jail or prison. I don't know which it was. But in any event, they get into a fight, the 2 of them. And so the train is stopped. Everybody kind of gets off the train. Oscar's guys, 4 or 5 gets off the train. The other guy, they gets off the train. So when the police come up, Anthony Peroni, he sees all these people. He doesn't know who's who, but he decides to stop Oscar and his people. Now, he had no facts, none, that these people were involved in the fight. When they were walking, they were innocently walking. But he decided to stop them mainly because they were black. And he did that. He goes and he detains them. And then he goes and talks with the train operator. She tells him, there's nothing. I don't know anything. I don't have anything. Now, what Peroni was supposed to do was let the guys go. There was no basis upon which to stop them. But what had happened is he had put his hands on one of these guys and yanked him off the train. Not Oscar at the time, but Oscar was trying to calm the other guys down. They were talking trash to the officers because they hadn't done anything. And so when Oscar reached over to tell his guys to be cool, Peroni sees that, and he comes up and whacks him and knocks him down, and then he says he's going to arrest him. And so at the time, none of these guys should have been arrested. But Peroni, basically, who was the real villain here, says that Oscar and another kid was going to be arrested. He then has Messerly come over. Messerly comes over. He's he's 6'7", he's 260 pounds. He's a big dude, right? Peroni's a big guy too. These are 250-pound guys that were big guys. And so they grab Oscar, throw him down, and in the process of pinning him down, the officer pulls out his gun and shoots him. And this was also captured on videos. And so there it was, and the people on the trains were horrified, because they'd shot and killed this kid, and it didn't appear that he had done anything to do that to justify it. And so from there, it became this huge outcry that, and Oscar was unarmed at the time, but the protest from it was as big as a protest can be in the Bay Area. I went to the funeral. I mean, there were people of all ethnic backgrounds. Many people had been on the train, people who had taken photos. We must have had 6 to 8 different cameras. It was an outrageous act on the part of the officer. Now, at the end of the day, and as a consequence, we wanted this officer prosecuted. So I wrote letters, engaged in community efforts to get this person prosecuted. And we ultimately did get him charged with a second-degree murder. And the case change of venue took place because they did a study and it determined that all the black people in the county thought he was guilty of murder, and half the white people thought he wasn't guilty. And so you had this racial divide, which is not uncommon. I've been involved in a lot of cases. Racial divides happen because people have different perspectives. But in any event, so the case got moved to LA County. And there, after a lengthy trial, he was found not guilty of murder, but found guilty of manslaughter. And the community was outraged by that. I mean, there were protests because for them, it was about race, and that this white officer killed this young black kid without justification. Well, the defense, but the case gets tried as a criminal defense case. And in the criminal defense case, race may not come into evidence. And so the community that was looking for the issues of race didn't find race in the case. In the case, the evidence did not come in about race. It came in as a strict defense case. The defense offered up, which was interesting, they offered up the notion that the officer had made a mistake and that he had essentially meant to pull his taser and not his firearm. And so that was his defense. Well, the contrary position to that was that after the shooting took place, the officer told everyone that he thought that Oscar was going for a gun. And he continued that position for about 3 weeks until he got another lawyer. And then when he got another lawyer, then it was a mistake. And so this was a fight to the end. He did make those comments in trials, and he was found guilty of involuntary manslaughter. Now, for us, the most important aspect of the case, aside from the fact that the verdict was kind of surprising, or maybe not really surprising, but disappointing, was that as a consequence of this case, most departments in the country had to be retrained on the use of the taser and to make sure that the taser was not in a position that you could make a mistake on. Now, and that is to say, it had to be on the other side from your gun hand, and it had to be turned around in a way such that you'd have to reach for it. Now, that is an important consideration for the case, and it was one of the secondary issues that came out that will ultimately have long-range benefits. The case went up on appeal, but it really showed the inadequacy of the criminal justice system when it has to deal with the questions of race, and they're inside of a criminal case without clear evidence, direct evidence that it's race. Now, most of you, I'm certain, are familiar with the issues surrounding the Trayvon Martin case. The Trayvon Martin, to me, was really as much of a racial profiling case as one could have without it being a police officer who, in his own mind, was a quasi-police officer. He called himself a quasi-law enforcement guy. Everything about it was that he was the guy in the neighborhood to do this. But just think about the things that Zimmerman said, that he thought that, now Trayvon had just gone to the store, he bought him some Skittles, he was watching the NBA basketball game that night, and he went to the store to buy some Skittles and some other things. So he's walking on the cell phone, talking to a young lady, girlfriend and I, but talking to her. And so Zimmerman, who's in the neighborhood, says, this guy looks like he's up to no good, or he's on drugs or something. Now the question is, what was he doing that would cause a reasonable person to think that, unless they had a state of mind that black people in that neighborhood didn't belong there. And so then he goes on to talk about he has something in his waistband. He was holding something in his other hand, was walking on slowly in the rain, looking at houses. Well, he thought he was on the phone talking to the girl and walking around. And there was nothing about the conduct in himself that was there. It's just that his own frame of mind, he had made some determinations from a racial point of view as to who he was. Then he says on to the radio dispatcher, quote, these assholes, they always get away with it. The question, what did he know? Who are these assholes? I mean, he couldn't be Trayvon, he didn't know who he was. And they're not saying, so it went to his state of mind as to his own notion about young African American men and making statements about it. Ultimately, Trayvon tells the girl on the phone that he's being followed by this creepy cracker that was following him. And ultimately, a confrontation took place. The facts in that confrontation were all spelled out in trial. There's no question that Zimmerman got beat up a little bit. And there's no question that Zimmerman made the fatal shot. Whether that's self-defense or not, or whether it was involuntary manslaughter, these are things that became significant issues in the case. I was a commentator on the case, and I certainly thought that the prosecution did not do a very good job. I thought that they never understood the case in ways that it should have been tried as a manslaughter case, because once I saw the facts that day and I saw they got beat up, I knew this case was a fight. And if it's a fight, then it's generally going to be a manslaughter case on the grounds that a person used more force than was reasonable, even if they had good faith belief. I'm sure you've seen this in criminal law 1A, that you can have a good faith but unreasonable belief that your life is in danger, and that becomes a manslaughter. Undercurrent of this case, of course, was the standing your ground laws, and ultimately not guilty verdict was there, and the community was outraged. Now, the community was outraged, one, because they didn't think the prosecution did a very good job. Number two, the issues of race had not been presented in the case. Number three, the jury panel itself did not have all women, and they had one mixed race person on it. And there was this sense that the jury never had a chance to get the kind of information that would give context to the case. And it was all, to me, the prosecution never understood this case. The case should have been tried by a person who had police practice experience, not a person with my kind of experience who understood the relationship between police and the community, etc. Unfortunately, prosecutors are never comfortable prosecuting police officers, largely because they got to get along with them every day, and it's part of the community in which they're in. That doesn't make them bad people, it just means it's a different way of looking at things when you have to deal with these kinds of cases. And so it was not surprising. Now, the takeaway message for me on Trayvon is that this is a case that should not have happened as well, because Mr. Zimmerman could have easily told Trayvon who he was, that he was a neighborhood watch person. He had not seen him in the neighborhood before. He just wanted to know who he was. Trayvon could have also said that I'm here because that my dad is here, and I'm just going home, and I live over here. It was a situation, in my view, and this is really mostly, in most cases I have, that you can people have to de-escalate situations. I always tell young African American men that you need to make sure you de-escalate. You don't have to respond to an officer who's being nasty and aggressive in a negative, aggressive way, because when they have guns and they have other stuff and you are at a disadvantage, and you don't want to be dead right. And so in this situation, I thought that each of these two men could have changed their position. And in fact, after the verdict came in, I have a nephew who was going to Penn State at the time, 22 years old. He calls me up and he says, Uncle John, he says, am I safe? And, you know, because of what happened in the case, he was very upset that this could happen to him. And I said to him, it's up to you to look out for yourself. You have to learn how to, you know, if you're in the wrong neighborhood, you're in some place, you have to learn how to de-escalate and figure out where you are. You are more likely to be shot and killed by gangsters and the police than you are by the Zimmerman types of the world. And that's the reality. That doesn't mean you're not mindful of the Zimmermans of the world, because they're there. But that's a function of where you are. Race was not something that came into this case, and it wasn't, even though the overriding aspect of this case was race, because everything that Zimmerman did was consistent with a person who had a racial mindset, a stereotypical notion about African-American men, African-American teenagers. That was part of how he approached the situation. But given the laws of evidence, and certainly decisions by the judge, none of it came into evidence. And so these two cases, they did produce one thing that I think is important, and that is that a community should step up and be heard when these kind of cases occur. That you should, in fact, protest. That you should, in fact, organize and make it be known. I was up in Santa Rosa today, and that's a case where the young boy, Andy Lopez was a 13-year-old boy, 14-year-old boy, was shot and killed by the police, who was carrying a make-believe AK-47. Without going to the merits of that case, the community itself has been very outspoken in getting to the police, talking to the police, talking to the DA, talking to the community, and letting people know and appreciate that these kind of issues are something that they care about. Because if you don't speak up, lawyers can only do so much. I mean, I certainly know that one good thing about being a lawyer is that there's a forum and a place for me to go. But community people don't often have that. And certainly in the Oscar case, Oscar Grant case, the community did speak up, and they ultimately were able to get a modified form of a community review board at BART, which had not been there before. And so you have to look to see if there's something you can do with a case that improves the social relationships for the future, certainly for the next case. Now, part of what I've been involved in, both in looking at both nationally and locally, is both the stop and frisk laws that have existed around the country. New York certainly had the biggest. I mean, they had a situation where they were stopping African-American boys on a routine basis. 14 and 24 being routinely stopped. There were thousands of people being stopped annually. Now, they're being stopped without probable cause, without reasonable suspicion. They were being stopped because they were in a certain neighborhood, or they were black on the corner. They had 2 or 3 people that were standing there together. And they would stop them, pat them down, and take a little information about them. All those people's information got put into a system, which can, in fact, come back and utilized by the police at some later point. The egregious nature of all of this was that only 2% of the African Americans who were stopped, the majority of the time, ever had any weapons on them. And even only the whites only had a 4%. So of these cases, of these thousands of people being stopped, there was a very little yield rate. And so and a federal judge said, wait a minute, if you're going to have such a low yield rate, and you're going to stop so many people, why do you think this program is successful? Because if you're not really finding anything, and you're stopping everybody in the community, why is that a successful program? And the argument was that, well, it stops crime. Well, since it reduces crime, so people would know that they're going to get stopped, so therefore they don't carry weapons. Well, what has happened is the federal judge declared the policy to be unconstitutional, and since then, that the stop and frisk numbers have been reduced. There are fewer numbers. But the crime has not gone up. And so there was never this belief that there was a connection between stop and frisk and the increase in crime, or the volume of crime. So for me, this was very important. I knew these lawyers. I talked with them a lot about what they were doing. And to me, this was, as I would say, this is good lawyer work. This is what lawyers should be doing, taking up on these kind of cases and seeing what they can get done with them. Because when you think about the millions of people who were stopped, maybe that will now cease. And you won't have people stopped unnecessarily so. The same thing happened in Philadelphia. In Philadelphia, it's a special place for me because my wife is from there, and I've had a chance to meet with some of the Philadelphia PD people there and develop relationships with them. Philadelphia had a similar kind of practice where they were stopping large numbers of people, and eventually they were able to file a lawsuit and prevail. Now, they had something else that was most important. They had a police chief who was kind of unaware of the stops, but once it was brought to his attention, he then really participated in the process, and they've been able to pull back on the number of people who were being stopped. It was declared to be unconstitutional. They now have a monitor in place, and the monitors are good because it holds the police accountable, like what we have in Oakland. At least we get a chance to see what you're doing, and in Philadelphia they have a monitor in place. Now what all this means is that a lot of what we've been doing is trying to accumulate data so that we can determine if racial profiling is existing, if we can identify the officers who are involved in it, and not so much to fire them, but to let them know that that they're doing something that should not be done, and that maybe we can deal with the issues of training and accountability. Part of our work in Oakland was to develop what they call an I-PASS system, and that is that officers who are arrested for certain types of crimes, whether it's we call 148s, 243, that's a resisting arrest, assault on a police officer. If there's no other underlying crime, then that information goes into the system. And so then you want to find out if there's outliers. Given the nature of the work that they're doing, we're looking for outliers. That is to see people who are outside of the norm for those kinds of arrests, and where their patrol office is, and etc. And so that has allowed for us to get a better sense of the conduct. It's just one of the things that you get to do. I have to tell you that one of the greatest aspects of having worked in the last 15 years is being in a position to participate in the rewriting of the policies and procedures within OPD, and to hold them accountable, and to meet with them. And I know it's difficult. It was difficult for them to have to respond to me and answer to me every week, but that's the way it was. That's the agreement we worked out. But also it allows for us to have definitive impact. Now, what we've done in Oakland is not surprisingly different than what a lot of other cities have done as well. We just happen, that is to say, LA and Detroit, Cincinnati, Washington, D.C., places in Ohio, now Portland and Seattle. They all have these agreements, these consent decrees. And these consent decrees allow for the Justice Department or people like myself to monitor these departments and really try to bring them up to speed in terms of quality and constitutional policing. And some of these places are just totally egregious. And so we've been I've been pleased that I've been part of this process nationwide in looking at these issues. I talked a little bit about earlier, and this is another part of the criminal justice system. There's this implicit bias within the system. People may or may not agree, but it's been my experience with this. And the reason why I find it most egregious is when I think about the drug laws. There is no doubt that there's a disparity in law enforcement, discriminatory law enforcement practice as it relates to bringing charges in cocaine and crack cocaine. If you look at these laws, and many of you may have seen them before, there is a 1 to 50 ratio between crack cocaine and powder cocaine. That one portion of crack cocaine, you need 50 times that amount for powder cocaine to get the same sentence. It is scandalous and it's totally outrageous. It came about because there was this view, and Congress had this view, given a bunch of gobbledygook at the time, that crack was so much worse than powder cocaine. Well, they ultimately come to the conclusion it's all bad. It's all bad. And so, but it's not one that's worse than the other. So as a consequence of that, they've been able to reduce from 1 to 18, which is still not right as far as I can see, but it is there. and more work is being done around those areas. 3 strikes and you're out has always been, three strikes has always been a sore spot, because initially it was supposed to be, when I was practicing criminal defense, and people may know this, it was supposed to be, the 3rd strike, it was supposed to be a violent felony. Well, the way the practice emerged in different counties, it didn't have to be a violent felony, it could just be a felony. And some of those cases resulted in people getting life sentences where the 3rd felony might be a pay with a product. That is to say, they stole some pizza, or they stole something extraordinarily minor, and they would get a life sentence. And many of these people went to jail for long, long periods of time. The most egregious in terms of the enforcement of the drug laws and the discriminatory impact is on the enforcement of the marijuana laws. ACLU just did a study, came out several months ago, and they went around the country and looked at the enforcement of marijuana laws and looked to see who got arrested. I put down here 6 times greater than white, but in some counties, it's 18, 20%. In small counties in the South and the Midwest, you'd be stunned at the disparity in the enforcement of the drug laws, particularly as it relates to marijuana. And the shocking part about all that is the data that they produced was that all races smoke marijuana at the same rate. They all smoke marijuana, they all use marijuana at the same rate. That's not to say everybody does it, but there's no difference in terms of African American communities doing 80% of the time and the white community doing 20%. That's just not true. It's been demonstrated. And I got a big note last week when Brooks of the New York Times said that when he was at Yale, he smoked dope all the time. And he never got arrested. But the kids in the neighborhood in New Haven, they did. And he was never worried about being arrested. And I used to have cases, and I could see where the kids in Piedmont would go home, and the black kids in East Oakland, they would get arrested and charged. And I can only tell you that this kind of disparity in law enforcement has a tremendous dilatory effect on the various communities. Because if you get the felony, then you are then placed in a position where your job opportunities, your educational opportunities are really impaired. And so as a consequence of this war on drugs, which really started with the Nixon administration and put forth more by Reagan and then later the Bush administration, we saw that there's 2 million people in jail. It's been an increase substantially from 1972 until now. And that it is largely being on the backs of the African American communities. And this has a tremendous impact upon employment opportunities, educational opportunities, etc. And Michelle Alexander, in her book, The New Jim Crow, I'm sure most of you know what Jim Crow is. That's legalized discrimination that was supposed to have been outlawed. But under mass incarceration, you in fact have now put forth another system of legalized discrimination. Because if you have a felony conviction, your opportunities for employment, opportunities for public events, your opportunities for housing, and a number of areas are limited. And it means that people with these kind of convictions are not going to be able to get certain kinds of jobs. They're going to get the jobs that nobody else wants, and they're going to be paid at much lower wages. And so this disparity in the law enforcement, or this mass incarceration of the African American community, has had a tremendous negative impact. Now, how does that impact me? Well, I represent mainly African American men, Hispanic males. All of them, for the most part, have had some contact with the criminal justice system. Many of them have felonies. When I represented the 119 individuals in the Riders case, I'd say 85% of them, if not 90, have felony convictions. Well, those are difficult cases when you have those kinds of backgrounds. It's easier when they don't have them. And so the impact is that then you can't get a job, you can't take care of yourself. The whole network of support systems come into play. Now, I'm hopeful that now that we have some reform, some new legislation in Colorado and Washington, that this can have a positive impact in reducing the level of arrest that you have in marijuana. Now, granted that there are some strict limitations on some of these, but it seems to me that it has the potential for reducing the criminal aspect of it. I know that, like alcohol, it does not necessarily do that, and particularly when the federal government has essentially says that marijuana is still a class, a controlled substance, and therefore it can in fact be subject to federal laws. Now, what the federal government has basically says that if you in Colorado or Washington and you're using it in a way that's consistent with the law there, they would not prosecute you. But what they are concerned about is people who are selling drugs to kids and those who are going across state lines and becoming huge drug dealers. Now, I don't know enough about that whole process to know what that means in terms of the cartels that are involved in this. All I'm really concerned about, from my point of view, is reducing the number of people who are in fact arrested and charged with the use of marijuana that has such a dilatory effect upon their lives and their family lives. I know this past week in the New Yorker magazine, the president spoke out about marijuana and basically says that, in essence, it's good for you. Well, it's not bad for you, I guess we could say. He says it's not bad for you. And how does he know? Because he did it for years. But that only means to me that it's like same-sex marriage. It is happening. Like it or not, it's happening. And same-sex marriages, which is a major civil rights issue and that's going forward, is going to happen in the vast majority of the country. I'm waiting to see what the U.S. Supreme Court says about what happened in Utah. But I think marijuana ultimately will also be one that will move in a way that it will be de-emphasized in terms of a federal offense and people being prosecuted for it, certainly at the level which has been done in the past, and I certainly hope so. Okay. The other important trends that I think are important as we look at this incarceration rate, and that's a big deal because incarceration affects people 20, 30, 40 years and affects their families and how they're going to survive and take care of them. Oh, and they're dispossessed people when they get out. They've been in jail a long time. The president most recently pardoned 8 people who had these very long sentences. And these were sentences that happened that when you had the 1 to 50 and they moved to 1 to 18, to the extent people had served longer sentences than they would have served at 1 to 18, the president has sought to pardon some of those people. Now, he pardoned 8 people. There's probably 3,000 that he hadn't pardoned. And so the question really is the president going to go take a closer look at those cases and pardon many more people. The other thing that was important, the U.S. Attorney General very recently said that as it relates to these maximum minimum charges, which go to the cocaine and the weight clauses that you have in drugs, that he is going to de-emphasize charging those cases. And this is really important because it gives the judges more flexibility. Under the maximum minimum sentencing charges for cases, the federal judges had very little flexibility. And there were a lot of injustices that occurred where people who had minimal criminal records that had some amount of drugs will wind up getting a 10, 15, 20-year sentence. And really outrageously harsh. And so there's some movement along these lines, I think, and hope that will decrease the amount of, the length of incarcerations that has sort of stacked up over the last 10 years. The 3-strike sentencing modification has happened, as it will happen, as a consequence of cases where the voters last, I think Proposition 36 essentially said that the 3rd strike now has to be a violent felony as opposed to some of the minor things that people have been convicted of for. And as a consequence of that, now counties have and the state has to go back, look at some of these sentences where people receive long sentences for non-violent offenses. Those cases will now be reevaluated, and certainly some of those sentences will be reduced back to consistent with their time. So that's happening on many areas, and I think this is very, very important, the reevaluation of sentences and get people out of custody who really don't belong in custody. No one believes that people who kill people and do very bad things should not be in prison. but there are a lot of people, the vast majority, a huge percentage of people who are presently incarcerated are really incarcerated for drug offenses. They may have been the second, third, or fourth time, but they were always minor. I have represented people who have been who've been convicted of a drug offense in their early careers and go back to jail 3 or 4 times for probation violation with no new offense. And so you can see the treadmill that exists there. Now, there's certainly an interest in all of this. The other side of one should be mindful of, to the extent that you have private business involved in prison health care and prisons and unions. The correctional union is a very powerful institution in this country, and they want to keep people in jail because having them in jail means there's jobs for them. If you start letting people out of custody and reduce the prison population, then you've got to reduce the correctional personnel. So these are all political issues that exist. I talked a little bit about the police gathering of stop data. This is, after Trayvon Martin, there was a huge issue about dealing with the question of racial profiling, and the way that it was thought best to occur is to engage in stop data collection, which essentially means when you get stopped by the police determines your race, figure out what your race is, your sex, what you were stopped for, where you searched, did they find anything, and maybe some few other things, but it allows for you to gather this data and to see whether or not there's a trend that people are being stopped because of their race. If so, who was it? What can you do about it? And so Congress itself was in the process, before things stopped and kind of gridlock, was in the process of looking at a federal stop gathering data that would require local police agencies to gather this data. That is still going on, but I think many police agencies are gathering this data. In most of those cases where there's a consent decree that's involved, like what we have, they are gathering this data. And so I'm hopeful that in the near future we're going to be in a better position to evaluate the data and see what really is there and to determine if it is there, what we can do about it. I know that we're doing something in Oakland right now. We just hired a new person to look at some of this data. And so I'm very hopeful that we're going to have some kind of impact on that in the near future. I want to just say finally, I know that being stopped may be viewed in many as a sort of insignificant, minor intrusion. I want to suggest to you that if it were you, I don't know that you would feel it to be a minor intrusion. The other side of it is these stops, and I've had them, where they create potentially dangerous situations. That it's not uncommon for a wrongful stop that could result in a person being killed, a person wound up being arrested because they have an attitude about it. And so I always worry that when you have racial profiling and you have two people with attitudes about it, then you're often going to have a very bad outcome. And when the ultimate gets to me, which then happens, I need to figure out what you did versus what they did. And generally, it's people responding to being stopped wrongfully, or being targeted wrongfully. I've had a number of cases where people really feel this kind of hurt, rage, and really a sense of second-class citizenship that you can have, and I think legitimately so. If you're being stopped because of your race and you really haven't done anything, and then you pull out of the car and you just put on the side. And I will say that I have represented people of all professions, men, black African-American men, of all stations in life, whether it's lawyers, doctors, professors, ordinary everyday people, students, it happens to everyone. And it's painful to me to see this kind of hurt. And the title of my book initially was When Grown Men Cry. And that came about as a consequence of me being involved in a case where this middle-class guy, working-class guy, started crying on the stands. And he was crying because he couldn't understand why this officer would do this to him. And it was such a painful thing to me to see that it became the focal point of the book that I wanted to write and did write. He, along with this officer in the Rodney King case, were sort of the focal points of my sense, because the officer seemed to be a decent young guy. I mean, he came to LAPD because LAPD is a good job, and he was going to make a considerable amount of money. He was a young guy from Kansas. He got in his car with jalopy and his 2 kids, and he drove to LA. He got this nice job at LAPD. Within months after getting out of the academy, he was embroiled in this vicious beating. And I couldn't fathom how this man, whom I took his deposition, could do this. And so I ultimately concluded that it was the culture of the department that he was in that allowed for that to happen. And one of the things I learned in all the departments I'm dealing with, each department has its own culture. And that culture ultimately is more protective of itself than it is protective in many ways of the community if the community attacks them in any way. And that's a reality that I deal with always. And so finally, my book that I did change the title to Blue versus Black, that's in the conflict between cops and minorities. I did that because when I was meeting with the people from St. Martin's Press, they came back to me and said, look, Burroughs, this book, the title of this book sounds like you were having suffering male menopause. I said, what? And so we changed the book. There was a question, which section of the bookstore was going to go in? Men healing section or a serious section. And so I opted to change, and we did work through a title that I became very comfortable with. But anyway, that's it for me. And I'm available for any questions that you may have if you have time left for that. Okay?
Do we have any questions? Yes, sir.
Hello, Mr. Burroughs. My name is Dominic from Fuller. I want to first thank you for coming to GGO and gracing us with giving us this lecture. It's an incredibly important lecture, especially for future attorneys. My question is, race being a social construct, is it in the best interest of minority communities to replace or eliminate the word race from being used to describe their communities? If not, what are the benefits of using race as a way to describe minority communities?
Well, that sounds like a sociology question. And I don't know that I'm equipped to deal with alternative discussions and the use of words. And that's not really an area that I'm in.
Can you go back to the microphone,
Yeah.
please?
I would only say that that question, profound as it might be, is not something that I feel that equipped to answer, because it's a denial of where we are, okay? Race is important. It is wherever you go, and I listen to various programs. So yesterday the president gave a response, and he was talking about how some people really just dislike him because he's an African American, and some people love him because he is. And he caught hell from the pundits because he was not supposed to talk about it. I have to tell you that, just as an abundance of strategy, I don't use race in cases unless I have clear evidence of it, because most people reject race. They don't want to make a decision that's founded in race, because that is a painful thing to do. Now, if it's a race discrimination case, everybody can do that because race is front and center. But then, even then, it is the one thing that people want to reject. So race is a challenging issue that I wrestle with all the time. But I recognize that if I can do the case without mentioning race, I do the case without mentioning race. It's enough that I'm there. That says a lot. But I don't use race unless there's clear evidence of it, because there's going to be a rejection of it without evidence of it. So I'm very careful. Now, other terms for it, I don't really know that point. I just know that you have to be mindful what race means in the social construct of where you are. And I just tried a case. I think I tried a case in Sacramento this past year, and I tried this case from an all-white jury who were people from Manteca up to the Oregon border and over to the Nevada border. And it was 3 blacks that were charged, and the officers, there were 3 white officers. Race was never discussed, by me. Although I think the defense tried to use it, and I had to go and deal with that because the defense wanted to use race because they want to use it in a stereotypic way. And those are the challenges that I face, is that defenses use race code words that you have to deal with. But that's the challenge of being a plaintiff's lawyer. Others?
Hi, my name is Cecilia Mahmood. Thank you again for being here. I just had a question because you mentioned the Trayvon Martin case, Oscar Grant, Rodney King, and the similarity between those cases really is that the community was left with a sense that justice was not delivered.
Absolutely, that's the point I wanted to make. Is
Yeah.
that it's really painful because if you put your hopes in the criminal justice system and issues of race are in it, you will come up empty, period. That is never going to happen. And some of the cases I mentioned earlier were classic examples. I'm sure there are countless others. But the community, there was a sense of emptiness in all those cases. Now, I was involved in the Trayvon Martin case and the Rodney King case. The Rodney King case on the criminal side, that was an explosion. I mean, the community just erupted. And we had, there was much rioting that took place because of that. In Trayvon Martin, he didn't have that. It was more peaceful protesting. Trayvon Martin, it was a mixed thing, but it was still a happiness. There was an unresolvedness to it. You felt empty. Now, I can appreciate what happened in Trayvon as a lawyer, just a lawyer, being a defense lawyer. I understood that. I didn't like it, but I understood it. And being a former prosecutor, I knew that too. But the general public would not get it and didn't see it and would not see it. Part of my job as a lawyer is in case that I'm involved like that, is I have to bring the client along. I have to help them understand that the outcome here may not be what you want, because you can have these expectations, unfulfilled expectations. So part of the job is helping clients understand that as well. But you're right about that, and I felt that same emptiness. But as I say, life is what it is, and lawyers, I appreciate you don't always get what you want. So you have to keep the struggle continues, as I say.
And what do you think the cause of that was? I mean, why is it because prosecutors are uncomfortable prosecuting officers, or is it the jury that's selected? I mean,
well, it's all part of that as well, but there's an uncomfortability with the issues of race as well. And you gotta, to some extent, you gotta give tribute to defense lawyers in those cases. Okay, like it or not, the lawyer, Trayvon Martin's, George Zimmerman's defense lawyer was very good. And so he was a better lawyer than the prosecution. Now, generally, cases ought not turn who the best lawyer is, but some of them do. Some of them do. And we've seen that history is replete with examples of outstanding criminal defense lawyers beating up on, prosecutors who were not equipped to handle the case. I didn't think the prosecutors in Trayvon Martin was really equipped. Now, I will say I thought the prosecutor in Oscar Grant was very good. I thought he was a warrior. He fought. I think it was a shock to him to be treated the way he was treated, because as a prosecutor, he's so used to the DA getting all the benefits from the judge. Then all of a sudden, you don't get any, and you're kind of wondering, where am I? And he had that feeling. Now I get that all the time, so I'm accustomed to that kind of treatment. But no, these are unresolved issues that, as lawyers move along, and my view on this, each group of lawyers have a responsibility to move the social agenda forward during their period of time. And so you will be, if you want, be tackling some of these issues. There has to be a movement on it, because look, we're in a far better place than we ever were. It's not like we're in Alabama in 1912 or something. You know, we're not there. But we're not as good as we can be, and that will take time. And we just have to be positive about these things. For that, at least that's my view. Okay? All right.
I'd like to invite everyone to join us at a reception outside with John. And also, we have some complimentary copies of the book, The Lone Dissenter of Jesse Carter, and another book having to do with structured teachers. Once again, please join me in thanking John.